After the longest federal government shutdown in American history and a spending bill the president deemed not enough, President Trump has declared a national emergency to fund the wall on the southern border. But there are critics and supporters of this decision. A lot of that centers around the question of presidential power. Does the president have the right to do this? And are there limits to presidential power? And if so, where are they? Joining me today to discuss those questions, Dr. Adam Carrington of Hillsdale College. All of that is coming up right here, right now. I'm Sam Chen, and this is Face the Issues. Good evening and welcome to Face the Issues. I'm Sam Chen. Thank you so much for being with us tonight. After the longest federal government shutdown in American history, the Congress passed a spending bill that the president deemed was not enough funding for his wall on the southern border. And so President Trump, as we know, has recently declared a national state of emergency to secure the funding for that border wall. But this has led to both supporters and critics of the decision, many saying that this is an overreach of executive power. But what exactly is executive power? How much does the executive have, and are there limits to it? Joining me to discuss those questions tonight is a guest of the show, Dr. Adam Carrington, who's the assistant professor of politics at Hillsdale College in Michigan. Dr. Carrington, welcome back to Face the Issues.
Glad to be back. Thanks for having me.
Oh, my pleasure. Thank you for being here. If anyone's watching the news, we're well aware of the government shutdown, of the spending bill that Congress passed, and this national declaration or declaration of a national emergency the president has put out. And like I said in the opening, there's critics of it, there are supporters of it. There are those who are critical or supportive of the wall. There are those who are critical and supportive of funding the wall. But then there are those who are either critical or supportive of specifically this action of declaring a national emergency and the question of executive power. And that's where we really want to focus our conversation today, on that question of executive power. And we can get into the specifics, but let me start at the 30,000-foot level before we get too deep into the specific terms. Can you give us a general overview of the ideas of executive power and executive privilege, where they come from and what the intent was?
Right, and I think that's a great place to start. And the idea of executive power actually doesn't originate with the Constitution or even our government. The argument is that there are three distinct functions of government that are naturally distinct, and that those are the making of laws, the carrying out or enforcing of laws, and the application or adjudication of disputes about the law. And the executive is obviously the second of those three. And the idea of executive power is that laws in and of themselves aren't enough to get what you want out of them. And that is that laws are meant to be obeyed. We pass laws to protect people, to pursue particular goods, but that laws need to be enforced because people won't always obey them just because they know them. So the 30,000-foot view of executive power is it is the power to enforce or carry out the laws so that they're obeyed according to what they were meant to be done.
Yeah, that makes sense. And you brought up the three different responsibilities or rights or roles, as you were saying. Can you just break down for our viewers briefly where the other two fall?
Right. The power to make laws rests with the legislative branch, and that's how the first article of the Constitution begins. All legislative power herein granted is given to or vested to a Congress of the United States. The power to apply or interpret the laws is given in Article 3 to the judicial power, to the courts of the United States. And all of this is meant for a unitary goal, and that unitary goal is the rule of law. Laws are supposed to rule, but the argument is for them to rule, you need them to be made, you need them to be carried out, you need them to be applied. That's only when they're all doing it within their lanes in the right manner can laws rule, and not tyrants or men or other of the options that the founders and our Constitution rejects.
Right. One of the complaints that we hear a lot is that different branches, the power that different branches have is expanding. And you hear this in different contexts. So some people believe Congress has too much power. Some say the Supreme Court has too much power. Some say the executive has too much power. From where you sit as a constitutional scholar, is there, do you see the branches, each of the branches expanding that power? And two, is there one that you feel has expanded more than the others?
Well, if you look at Federalist 51, which many consider the definitive explanation of the Constitution, I mean the Federalist Papers as a whole, they say that the branches will try to expand their powers as far as they can because they're made up of men, human beings, and those human beings are ambitious and they'll want to push the boundaries. And the idea is that we're going to give tools to each branch to push back. It's going to be a bit of gravity holding each other in equilibrium. And I would say that there are two problems that have arisen regarding that in the current state of affairs. One is that Congress has been unwilling, and I think there are reasons we could possibly get into there for this. They have been unwilling to assert their own prerogatives with the force that they have in the past. And I think both the courts and the executive have stepped in to take up the slack. And in addition, I think there is this issue of the bureaucracy itself. In order to fight corruption and for other reasons, we have a lot of independent administrators that operate sometimes outside of all three branches and almost are a fourth branch of government. And a lot of government power is exercised there as well. So I think both of those have become distortions in the system that have made it harder for it to function exactly as it was intended and set up in the original Constitution.
Right. Senator Ben Sasse of Nebraska, who's on the Judiciary Committee, recently echoed those sentiments that you just had. And he suggested during a hearing that the founders intended for the legislative branch to be the most powerful. I don't know if most powerful is the right term there, but that there is a certain powers, certain rights, certain responsibilities assigned to the legislative branch. And Senator Sasse argues in large part because of their proximity to the people. But then he adds that in recent history, the Congress has continuously punted that responsibility, which he said has created an excess of power and authority in either the executive or the judiciary branch. And what he was pointing out was that the politicization of judicial hearings is one of these consequences. Is that kind of the same thing that you're seeing and that you're saying?
I think so. And I should say this is quite apart from what you think government should be doing. This is quite apart from whether you're to the left or right on policy outcomes. This is all about how do we make decisions? How do we implement those decisions? And what's the right method? And I think that's fairly accurate, that the legislative branch, and why did they do this? Why have they been reticent to assert their powers? Part of it's partisanship, that they have seen themselves more as Democrats or Republicans than as members of Congress to protect their prerogatives against other branches. The other has been wanting to pass the buck on tough decisions. So what sometimes Congress will do is pass really vague legislation saying we want clean water, we want safe streets, we want preventative health care for women.
Right.
And who's against those things, right?
Right.
But in implementing them, there's sometimes tough decisions that have to be made that are hard, and and Congress has found it sometimes in their interest to pass the vague positive things and then pass the buck to the executive or to the courts or to bureaucrats to actually decide the particular regulations. And one more thing I'd add about Senator Sasse's comment is I think the founders were aware that the legislative branch would be the most naturally powerful because it looks most like rule by the people. Our Constitution begins, we the people, and the legislative power is meant to, in many ways, mimic rule by the people as a whole. But what they then did is say, we don't want the legislative branch taking over the other branches. And so they actually introduced checks and balances as a way to bolster the strength of the other branches to keep them independent, because the experience of the founders had been in the states in the 1780s that these powers legislative power is a vortex, the Federalist Papers call it, that takes all other powers in with it, and they wanted to avoid that. So the attempt is to keep them distinct, even if the legislative power is naturally the most able to assert itself.
Right. No, that makes sense. I always refer to the separation of powers and the checks and balances as a government that is independently dependent. Each branch needs the others to operate, but they're not really working together like a group project.
Right. I think that's a good way to put it.
Follow-up question on that. If the legislative branch is punting, and this is where a lot of the current situation at the border comes in, where the president wants a certain dollar amount of funding, the Congress is unwilling to give it. Obviously, we can end up in a situation where the government is shut down. But if the legislative branch is punting on some of these responsibilities, as you're suggesting, what, in the larger view of it, what's the danger that you see in that, if any?
I think the danger is twofold. One is that we will increasingly have executive officers or bureaucrats making laws and then executing them at the same time. And if you look again to the Federalist Papers, Federalist 47 says, quoting the French thinker Montesquieu that was so influential on the founders, says, to combine any of those three powers is to create tyranny. Because if you allow the people that make the laws to apply them, then they can do so in an arbitrary fashion. They can punish enemies and help friends, and that is a danger to the liberty of people that want to only exist under the rule of law. And the other is, I actually think we'll get worse laws. That I think the founders set up each branch not just to exercise a power, but they constructed the branch so it would be better at doing its particular task. So the legislature is set up to make laws well. The executive is set up to execute them well. The judiciary is set up to apply and interpret them well. And when they start to do some other branch's job, it's not just a threat of tyranny, it's also a threat of inefficiency. Sure. That the president will be bad at lawmaking, Congress would be bad at executing, the judiciary would be bad at the other two, and we'll get the worst of both worlds, a tyrannical government that is ineffective at its own tyranny.
Wow. That's a good note to end this first segment on. Dr. Carrington, thank you for joining us. Don't go away. We will be right back. Welcome back to Face the Issues. Dr. Carrington, thank you again for taking the time to join us. And in the first segment that we were just talking about, presidential power and the roles and the powers of the different branches of government. And we left off where you expressed a concern about where it goes if it continues such that each branch doesn't essentially play in their own lane. A lot of people are pointing to that breakdown as what led us to this current situation with the declaration of a national state of emergency, with the government shutdown, et cetera, with the situation of the border wall on the southern border. Let me ask you this. The president declares a national emergency on the southern border, and this is how he's going to secure the funding for the border wall. Before we go any further, how does such a declaration work?
This originates in the 1970s, and broadly, I should say, the idea that a president would be the one branch to deal with a national emergency first and foremost actually goes back to the theory of separation of powers. The president is a unitary executive, therefore he can act swiftly, and often emergencies are momentary arisings that need swift action, and he is much more in the position to do so than the other branches. But where this originates is the Congress attempted to codify a little bit how does a national emergency get declared? In the 70s, they passed the National Emergency Act, and this act listed off a large number of instances, broadly defined, where a president could declare a national emergency, and then passed other statutes or subsections that then detailed, well, what tools does a president have to act in those kind of emergencies to deal with whatever the particular situation is. So that's the origin, and so that's why the president officially declares one, and then that is supposed to unlock otherwise unusable powers to deal with whatever particular situation he's declared to be such an emergency.
Right. Okay. That makes sense, and I appreciate that context. So as you know, as all of our viewers know, there's been a lot of discussion over this declaration, and there are members of Congress on both sides of the aisle who are calling this a power grab. There are those referring to it as unconstitutional power grab. And I just want to be clear that to me, there's a difference between a power grab and one that is unconstitutional. And I'm not sure that's a line that is often drawn in this conversation. That is one thing to say the president is looking to expand his power. It's a whole nother thing to say that this expansion is unconstitutional. Is there a line there that the courts have ruled on before? Is there a precedent there that kind of draws a line between the two?
There are several lines the court has tried to draw regarding power grabs, at least in general. And part of the way to think about that, at least as far as the line goes, is anytime the president signs a law or suggests a law, it's a power grab, because the more laws there are, the more executive power he has to wield, because there are more laws to enforce. But the constitutional line is, when does the president act outside of either what the Constitution directly gives him or what Congress has given him by giving a law to enforce? And that's the question that needs to be asked here. And in like situations, has Congress, by the way, without giving up its own legislative power, has it given the president the authority to do this, or is there some inherent constitutional power? And that really gets set out in cases such as U.S. v. Curtis Wright, or Youngstown Steel versus Sawyer, some cases from the 30s and 50s, and internally and this is interesting because this is before the court again, the concept of the non-delegation doctrine, that whatever Congress gives the president to do, it must be enforcing laws, not making them. So that kind of case law has been where some of the general lines have been drawn that I think need to be brought to bear when you're looking at a situation like this national emergency declaration.
Sure. And that last thing that you brought up there, is that even, so are they arguing that if Congress tries to forfeit its own rights and responsibilities in drafting law, the executive can't assume those responsibilities?
Correct. And actually, there's a case before the court that could be out any day, will be out very soon, called Gundy versus United States, where the argument was the attorney general, as an officer under the executive, was basically told, do whatever you want as far as applying a law about a certain subset of criminals. And the argument is, you can't just let the executive write the rules, even if the legislative branch wants to give that up. I sometimes tell my students, you can't white elephant gift your party, your power to another branch. You can't say, well, let's have a Christmas party. I don't want this legislative power. You can have it.
Sure.
You are tasked to do it. And the question here, I think, is actually less about the giving up of power, but the president is so used to, and this is the presidency, not just President Trump, to having wide delegations of power, that even when Congress specifies, and we can talk about where the current law lands for this emergency, but even when Congress is more specific, even when it does its job, the president is so used to being able to exert wide discretion that it's almost as if the presidency is not even used all the time to having to stay within its lane.
Right. And that's actually one of the things that has come up a number of times, which is going back and looking at past declarations or even past executive orders that weren't made during declarations of national emergencies. And so one of the comparisons that's come up is this situation here. To your point, Congress passes funding. It's funding that the president deems as insufficient. And so there's this declaration which frees them, that gives them the power to be able to secure some of this funding. And there's comparison between this situation and not that long ago when President Obama has signed an executive order on immigration policy. And that was seen as such an expansion that even Saturday Night Live did a Schoolhouse Rock parody of the expansion of the executive privilege. In your mind, how do these two compare? Is there a comparison?
I show that SNL clip in my classes, by the way. But yes. Well, on one hand, they couldn't be different as far as policy goal. The President Obama's was an attempt to expand the number of persons here legally, and President Trump's desire to expand walls and barriers along the border is an attempt to limit the amount of persons here illegally. And but I think after that, there is an overlap where these are both very assertive and expansive readings of the statutory text that both have argued, and there are documents for both administrations saying that this is within the law, saying that they are merely applying or carrying out a law that Congress has passed. At the same time, I think both are, at best, very generous readings of what the president is allowed to do in ways that I think certainly got President Obama into legal trouble, and I think will get President Trump. There'll be some serious questions as to whether this is not the same thing as far as expansive executive power.
Sure. And let me follow up with you on that question. You're talking about how this is an expansive power that it got President Obama in legal trouble and may get President Trump in legal trouble. As a constitutional scholar, we talked earlier about why these powers exist. What, in your mind, do you see as a proper use of this power?
Well, I think the proper use of the power has to focus on the fact that the president is charged in Article 2 of the Constitution to make sure the laws are faithfully executed, that they are faithfully carried out. And I think what that requires is that we read the statutes they're leaning on carefully, and that we say that words that are in laws are not meant to be manipulated by men, but followed by rulers in order to make sure that we have the rule of law. And that's where I see some difficulties, both with what President Obama did, and I also see some trouble with what President Trump has done, even more so with what he says he can do based on the statutory text. I think there are reasons that the text is a little more confined, and that building a border wall for immigration enforcement might not be where the power is on the National Emergency Declaration.
Understood. Dr. Carrington, thank you again. Don't go away. We'll be right back. Welcome back to Face the Issues. Dr. Carrington, riveting conversation. I appreciate your insights, especially into the nuance over the current situation on the southern border and with the the Declaration of National Emergency. To punctuate a point that you said at the very, very beginning of the program, in your mind, this has much less to do with what the actual policy is and much more to do with the structure of our republic.
Yes, and that's something I think that should be emphasized. You can be against the wall and for that this is a legitimate exertion of executive power. You can be the reverse. You can be for the wall and deny that the statutes that the president and his administration are leaning on allow him to do so. And I think that being able to separate those things is an insight of our Constitution, that we don't just ask what we want to do, we ask how we want to do it, because how we want to do it is a protection for good yet safe government.
Mm-hmm. And I mean, isn't it true that the Constitution really isn't a document about what, but about how?
And I think there are some ends that are posited. You know, the Bill of Rights do some limits. The preamble gives some broad guidelines, but ultimately we live in a government that is based on the consent of the people. We, the people of the United States, ordain and establish the Constitution. Sure. The Declaration is based on the consent of the governed as the legitimate rule of how governments are supposed to operate. So while we do have some overall purposes, we also leave a lot to the people to decide what do they want out of their government. How do you exercise self-government? And the Constitution was the accruing of wisdom in the past for what are the ways we can make the best decisions, but still leave the decisions to us.
To us, yeah. Let me ask you this final question then. What is it that Congress or the government or even us as constituents and voters, what is it that we can or should do to ultimately rebalance that power?
I think we have to educate ourselves to not just the generalities of separation of powers, but commit to understanding them as citizens who are voting. I think we have to vote, and we have to vote not just based on our policy outcomes, but what we want to uphold in the structure of government. And I think that we just have to be willing to participate in the debate about what are these powers and vote according to what we think they should be, and make those demands of our politicians, make those demands of our elected leaders. And I would say that those are the kind of things that are the base level that a government of the people, by the people, for the people, if it's not going to perish from the earth, as Lincoln says, it's up to us to keep it alive and to keep it thriving.
Sure. And as Franklin said, right, we're one, if we can keep it, and it seems like we're almost one generation away from those infamous words. Dr. Carrington, thank you so much for joining us. I know you'll be joining us again next week as well as we discuss some of the other things going around with executive power, but I appreciate your time today.
It was a pleasure. Thanks for having me.
Absolutely. And that is all the time we have tonight. Thank you so much for joining us. Continue this conversation with us online. Just remember to use the hashtag #FaceTheIssues. And join us again next week as Dr. Adam Carrington will be back as we continue this important conversation on executive privilege with a specific focus on the question of impeachment. My name is Sam Chen on behalf of all of us here at Face the Issues. Thank you and good night.